equals contract. Whenever you see or hear the word law, it is synonymous with the word contract. Anyone here not have a grasp on the meaning of the word contract or agreement? Okay. So, law enforcement is contract enforcement. They enforce all kinds of contracts. A court of law is a court of contract. So, in the world of contracts, we have offers, we have acceptances, refusals. But a contract is made when there is an offer and an acceptance. Now, anytime there's an offer, you have three ways in which, I'm going to break down the first one. You have three ways in which you can respond to any offer. There's acceptance, which has three different forms in of itself. There's refusal and argument. Okay? So rather than accept or refuse the offer, you'll argue the terms of the offer. Now, acceptance, which is the only one creditors are concerned with, because the other two are dishonors. Okay? In the world of contract, when an offer is made, the only way to be an honor is an acceptance. Now, does that mean you just accept everything as it is? Like if somebody comes and makes you the offer, hey, we're going to take your car away from you. You go, well, I'm a creditor. I guess I got to accept. Go ahead. Okay? No. There are three forms of acceptance: expressed, implied, and conditional. Expressed acceptance is, I accept. You expressly accept the offer. Implied can come in many forms. It can come through your performance. For example, you sit down at a table in a restaurant, you grab the menu and you start ordering stuff off the menu. Guess what? You've now entered a contract. You agreed by sitting down and ordering off the menu to pay the prices listed on the menu for any of the food that you order. That's a contract. Contracts do not have to be written. Give me your breakdown of contracts, the thing about written contracts. You know, when you, the breakdown of a written contract, how it's not a contract, how a contract is.
Yes.
Yes, this is Gordon. This is another one of my mentors.
Good evening, ladies and gentlemen. As Brandon tells you, it's all contract law. And contracts are either express or implied. The express or manifest viva voce, or by writing. The implied are shown by silence, by acts, or by signs. In a particular contract book, and I'd recommend all of you get a hold of either Restatement Second, or there's another one, Brian Blum puts out contracts, explanations, and examples. Contracts are very basic. There's no real ambiguity among the professionals out there how they define it. So a good contract book, either Restatement Second, Williston on Contracts, etc., will give you some insight you can't imagine about contracts. But on page 50 of Brian Blum's, in the footnote at the bottom of page 50, and you can go on the internet and get it free, is a statement that says thus: in colloquial speech, people often talk of signing a contract. Signing a contract. Strictly speaking, this is inaccurate terminology. The contract is the legal relationship between the parties, and the document that is signed is actually the record or memorial of that contract. So it's hard to imagine. You shouldn't be going into court. I got my contract right here. No, I've got my record or memorial of your contract. Your contract's what you agreed to. It's then memorialized or recorded. Then there's all sorts of other parts of law that come in, and I'm sure Brandon will get into it, so as I get called up for it, we can maybe dig deeper into it. But that contract book and paying attention to a few basics will just clear the skies for you for what you're dealing with.
Thank you.
Yes?
Filling that out, as far as the books that you're referring to, like,
The name
Well,
of the-
restatement second is just as it sounds. Restatement second. And that's a short name for, and I forgot the full name of it, but it's standard accepted everywhere. You can go on the internet and look up restatement second. And the book actually is a very thick book, and it gives lots of examples and rules and guidelines to what a contract is. And it's really unique because you have to read it to understand what a contract is. You think you understand what one is, but when you read that, it gives all the nuances and little minutiae, and it's really exciting reading, quite frankly, because you can see how it actually applies to you in your daily life. Yes?
a quick question about the implied and everything. A contract is meeting of the minds, true or false?
A contract is a meeting of the minds. Yes, but do you know what meeting of the minds mean? Let me give you an example.
Both sides understand what's going
Oh,
on?
big mistake. U.S. citizens don't understand a lot of things. Let's look at it. Let's look at a simple example. I'll try and keep this short and give the floor back to Brandon. I want to buy your bicycle. You say, I want $50 for it. I say, okay. We have a meeting of the minds, consideration is passed, etc. A lot of us are under the assumption, that's a contract. We have a meeting of the minds. Police officer says to you, get over here. Well, if you went over, did you know you just made a contract?
How
You
about,
didn't realize it. I just going over there. Wait a minute.
No meeting of the minds.
There was
Yeah,
a
there
meeting of the
was.
minds. It said thusly out of these contract books. You'll like it. Motive is determined objectively. I can't hear what you're saying over what you're doing. That's what the judge is going to do when he looks at you. You're going to go in there and file a complaint. And you're going to say, I didn't agree to pay this money on this thing, or, you know, now I don't want to pay it. And he's going to say, well, you paid it for 3 months. Seems to me that's exactly what you intended, because you can't testify in your own case. So all he can look to is motive is determined objectively, not subjectively, objectively. What are you doing? I can't hear you. You're like a child getting beat. I love you, I love you. I don't think the child thinks you love him. He can't hear what you're saying over what you're doing. Your actions speak louder than words. And that gets really detailed with contract stuff. Policeman says, get over here.
The Godfather says your brain is going to splash on this paper or your signature, legal contract. You put your signature, you accept it.
Why are you agreeing that? Because you think you're under duress? So you're cooperating because you're under duress? Miranda versus Arizona, the Supreme Court judge had a wonderful thing to say about you people that give in to. It is not just the subnormal or woefully ignorant who succumb to the interrogator's imprecations. Supreme Court judge says if you give in to that kind of stuff, you're subnormal and woefully ignorant. And that's the way they look at you. And you say, wait a minute, he's going to beat me. No, you think he's going to beat you. And if you conduct yourself as a sovereign or in harmony as one of God's children, they're going to surprise you that this government, I'm going to tell you, I've had so many experiences with this government. I have nothing but love and respect for it. And in fact, it is a perfect government. And Brandon will explain to you why it's a perfect government. But see, you don't understand what perfect is. You think you do. Perfect means flawless, right? Yes, it does. But it also means whole or complete. This government gives you the republic and it gives you the democracy. Which one would you like to live under? Well, you're making your choice. Are you a U.S. citizen? i.e. 28 U.S.C. 3002 subsection 15, United States is a federal corporation. Are you a corporate citizen or a state citizen? Tashiro versus Jordan, 201 California, Supreme Court case. That there is a citizenship of the United States and a citizenship of a state. and the privileges and immunities of one are not the same as the other, is well established by the decisions of the courts of this country. My country is California. The United... What's that? Toshiro versus Jordan, 201 California, 1949. By the decisions, that's plural, the Supreme Courts of the United States, of the country California, the country Arizona, the country Texas. I can't tell you how many times they've explained this to the people. But once again, you know, we have eyes that can't see and ears that can't hear. That's what God told us. Well, I can see and I can hear. Can you? We'll see.
Thank you, sir. You can see why I like Gordon to give his little spiels. He's got this stuff memorized. I couldn't quote you anything unless I'm holding it in front of me. All righty.
There is another book that's a very excellent book. It's called Contracts, and it's written by Fitzgerald.
Oh, I've got that one. Contracts by Fitzgerald. Yeah, it is a good book. All righty, so I'm actually going to take, I'll do a quick rundown of the documents contained in tonight's class. One document's just called Acceptance. It's basically a mishmash of different sources, Bouvier's, Black's, different law sources on the definitions and different types of acceptance. There's a document in there, How to Do a Conditional Acceptance. And then I actually put in there a sample conditional acceptance in regards to receiving a frivolous filing letter. Now, if you correctly filled out all your forms and all the data matches up with your records and you receive a frivolous filing, what is a frivolous filing letter? It's an offer. Now, got three doors you can go through. You can accept, you can remain silent, which is like a refusal or a rejection or an implied acceptance of the terms. You can argue with them, send them a letter, say, oh, it's not frivolous. I did this, and that, and Brandon told me this is how I fill out a form. Right? That'll get you real far. Or you can do a conditional acceptance, and that's a sample of a conditional acceptance in regards to a frivolous filing letter, and I will read it through tonight. Okay. Alrighty, so let's hear what the various legal dictionaries and whatnot have to say about acceptance. Acceptance, an express act or implication by conduct that manifests assent to the terms of an offer in a manner invited or required by the offer. Now that's an important phrase right there. Invited or required by the offer. Because in a conditional acceptance, you're going to be setting and inviting the terms of the acceptance of your offer. Because on a conditional acceptance, you get transformed from the offeree into the offerer. You basically now have a counter-offer. So that a binding contract is formed. The exercise of power conferred by an offer by performance of some act. The act of a person to whom something is offered or tendered by another, whereby the offeree demonstrates through an act invited by the offer an intention of retaining the subject of the offer. Again, did it say anything about signing anything? No. In the law of contracts, acceptance is one person's compliance with the terms of an offer. Get over here. Contract. Acceptance occurs in the law of insurance when an insurer agrees to receive a person's application for insurance and to issue a policy protecting the person against certain risks such as fire or theft. When a person who is offered a gift by someone keeps the gift, this indicates his or her acceptance of it. Like a Social Security number. You accepted the gift. Acceptance also occurs when a bank pays a check written by a customer who has a checking account with that bank. Bank pays the check. In business dealings between merchants, which is governed by law of sales, a buyer demonstrates his or her acceptance of goods that are not exactly what he or she had ordered from the seller by telling the seller that he or she will keep the goods even though they are not what was ordered. By failing to reject the goods or by doing something to the goods inconsistent with the seller's ownership of them, such as selling the goods to consumers of the buyer's store. Okay, types of acceptance. An acceptance may be conditional, expressed, or implied. Conditional acceptance. A conditional acceptance, sometimes called a qualified acceptance, occurs when a person to whom an offer has been made tells the offerer that he or she is willing to agree to the offer provided that some changes are made in the terms or that some condition or event occurs. This type of acceptance operates as a counteroffer. A counteroffer must be accepted by the original offerer before a contract can be established between the parties. Now, isn't that interesting? There is no contract until the original offerer has met your terms of the counteroffer. So, if an offer is made and you counteroffer or conditionally accept, putting terms upon your conditional acceptance, you've now put the burden on the opposing party of meeting the terms of your contract before there is a contract. Okay, another type of conditional acceptance occurs when a drawee promises to pay a draft upon the fulfillment of a condition, such as shipment of goods reaching its destination on dates specified in the contract. Express acceptance. An express acceptance occurs when a person clearly and explicitly agrees to an offer or agrees to pay a draft that is presented for payment. Implied acceptance. An implied acceptance is one that is not directly stated but is demonstrated by any acts indicating a person's assent to the proposed bargain. An implied acceptance occurs when a shopper selects an item in a supermarket and pays the cashier for it. The shopper's conduct indicates that he or she has agreed to the supermarket owner's offer to sell the item for the price stated on it. Okay, this is a definition of acceptance. I believe this one's from Bouvier's. Acceptance, number 1, receiving something from another with the intent to keep it and showing that this was based on a previous agreement. Number 2, agreeing verbally or in writing to the terms of a contract, which is one of the requirements to show there was a contract, an offer and an acceptance to that offer. A written offer can be accepted only in writing. Receiving goods, well, they should reword that because it should be a written offer is only accepted, expressly accepted, with a written response. Because a written notice sent to you that has on there the terms of the response and you fail to meet the terms of the response, you've done an implicit or an implied acceptance. Let me give you an example. Well, I'm just going to simplify it. You get letters from the IRS, right? Well, if you just ignore them, does the IRS go away? No. If you get a notice of levy and you don't respond or agree, is that levy going to happen? Yeah, you better believe it. Notice of lien? Will the lien go up if you don't respond? Well, how can it? They sent you a written notice and you didn't expressly accept. See? They put right on the notice the forms of response. They give you an option. I've seen almost every letter the IRS sends out, and they always give you an option. Hey, you could do this or you could do nothing, but if you do nothing, you're going to get a penalty, we're going to do this, we're going to levy. Even on a notice to levy or lien. Like, oh, and if you want to address this, you feel that it's out of order, you can contact us and we'll have an administrative hearing about it. Okay? So the IRS isn't like some big bad guy that just comes around beating people with a club. They give you every opportunity to come into honor of the contract. Alrighty, number 4. Agreement to pay bill of exchange, which can be an absolute acceptance to pay as the bill is written, or conditional acceptance to pay only when some condition actually occurs, such as the shipment or delivery of certain goods. Acceptance is most often used in factual determination of whether a contract was entered into. Take that toothpick out of your mouth. All right, now here's a list of 15, I guess, definitions of acceptance that I pulled out of something. Acceptance. Number 1, an agreement to receive something which has been offered. Number 2, to complete the contract, the acceptance must be absolute and past recall and communicated to the party making the offer at the time and place appointed. The acceptance of rent after a notice to quit, in general, waives the notice to quit. So, I get a notice to pay or quit, or just a notice to quit even, and I pay the rent, and the landlord accepts the rent, they've now waived the terms of their notice to quit because they accepted the payment by their performance. I didn't have to write anything on the check. I didn't have to write on the check, if you cash this check, you agree not to follow through on your notice to quit.
Define notice to quit, please.
Notice to quit is get the hell out. You haven't paid. Okay, number 4. The acceptance may be expressed as when it is openly declared by the party to be bound by it, or implied as where the party acts as if he had accepted. The offer and acceptance must be in some medium understood by both parties. Now, you may think that means that you need to be knowledgeable that a contract is happening. But if you speak English and I say get over here and you do it, is that not something that both parties understand? Now, if you don't speak English and I say get over here and you don't do anything, I can't really say that you performed or honored or dishonored a contract. There's not necessarily a meeting of the minds. This mind doesn't comprehend your language. Where was I? Oh, here's a good one. It may be language, is that a word? Symbolical? I guess it is. Oral or written. For example, persons deaf and dumb may contract by symbolical or written language. At auction sales, the contract, generally symbolic, a nod, a wink, or some other sign by one party, imports that he makes an offer, and knocking down a hammer by the other that he agrees to it. This subject is further considered under the articles assent and offer. That may be a reference to something. Acceptance, we'll skip that one. Acceptance must be made, draw E. I'm going to kind of skip over some of the negotiable instrument stuff. because that's not really the topic for tonight, although any negotiable instrument or tender offer is a contract or an offer to contract. So if you write on a piece of paper, my payment for $200, and sign it, and you send it to the CFO of a bank for your house, or well, maybe you write $200,000 on there, and they accept it, you just made a payment for $200,000. And if you knew how to make a claim and stand behind your claim, and how to conditionally accept anything they throw at you, your claim will stay on top. And that piece of paper that just says, I'm paying you $200 with this piece of paper, signed, could be considered their acceptance of your $200,000. Okay. All right. I feel like I'm beating a dead horse with this document. All righty. So,
Going back to the policeman system.
hold on. Let's pass the microphones around. We got to give this to the benefit of those who download and those who... Can you pass that back for me?
What would be your answer to the policeman that says, get over here? No, sir?
That's a rejection. That's a dishonor. You could say that, but then what's he going to say? Resisting something.
Resistance is futile.
Okay? What if you asked a question? What if you conditionally accept? I accept your offer to come over there, conditioned upon proof of claim that you have some authority to order me over there, or conditioned upon proof of claim that I can't stand here to hear what you have to say. You see what I've done? I've conditionally accepted and I put terms. I accept, condition upon, now you have to prove a claim. Now, I could even put more onto that. I could put terms under which I expect their response to come. How will I define a proof of claim? Upon proof of claim signed under your unlimited commercial liability under penalties of perjury.
Public servant questionnaire?
No, I'm saying that's what I would say. I'm giving you the terms of the response I expect. It was funny, I talked to someone this afternoon, and they said that at one point they were in court and there was a judgment against them. Okay? And upon this, and this judgment was against them. Okay? He said, I accept, condition upon proof of claim that there is some kind of money I can pay this with. And it was done. His contract, his claim was put on top. He didn't have to pay. Is he here? Where are you at? Is Sean here? Oh, is he in the back? Okay. So, very simple. You know, condition upon proof of claim that I can't pay this with coffee beans. Proof of claim consisting of a signed, a sworn statement under your unlimited commercial liability under penalties of perjury that I can't pay this in coffee beans. Will they sign a statement under penalties of perjury that you can't pay it in coffee beans? No, they won't. So your offer goes on top. So you walk to the store, get a couple hundred coffee beans, walk back into the court, well, here's my payment. There was actually a judge who said this to a guy in court. He says, well, Your Honor, since there is no lawful tender, how do you expect me to pay this? The judge says, I don't care if you pay it in coffee beans. The guy went to the grocery store, got a couple thousand coffee beans, and dropped them off with the clerk. Here you go. Judge said I can pay in coffee beans. Now, I guarantee you not too many judges said that again after he did. Now they say, typically when patriots go into court and they use these types of statements, the judge will say something like this: whatever you usually pay your debts with, that's the method you use to pay this one. I accept that, Your Honor, conditioned upon proof of claim that I pay debts. Is he going to be able to sign a sworn statement under penalties of perjury that I pay debts? No, he has no personal knowledge. Hold on, do you have a microphone? Yeah, okay.
I had a friend that when he went to court and they called him up, he stood up, screamed out, "I am surrendering the defendant into your custody," walked up, slapped his birth certificate on the bench and walked out and never got contacted after
Yeah,
that.
he made an offer. Did they reject his offer? No. He handed over a surety. All they want in a court is a surety. They laughed, yeah, they laughed, but he walked out. Now remember, what they say and what they do are two different things usually. Like a judge may seem like he's dishonoring you, may seem like what he's saying is not going your way, but watch him turn around and do something different. Because remember, he's got to keep all the rest of the sheeple in the room convinced that things work a certain way. Okay? If he just lets all the cattle know that you could just walk up here and say this, and we're just going to lie down and let you walk on us, well, then they'll have chaos in the streets. Because truly, debtors would use this information, this knowledge, these procedures and processes to become immune to things that they shouldn't really be immune to. See, we agreed to having contract enforcement officers because we want contracts enforced, don't we? I mean, who thinks we should just all be able to drive whatever speed we want on whatever streets we want? Yeah. Do you have kids? Do you have kids? You think it's okay for people to just drive 200 miles an hour down any street?
Generally speaking, people are not going to act as crazy as you think they would if there is no restriction. Yeah, I believe.
Really, because with these laws in place, people act that crazy. With there being some kind of penalty, people do these things. That's like saying,
Would you
oh,
swear
we
on
shouldn't
the
have a murder,
perjury?
we shouldn't have a law against murder or stealing because people aren't going to do it anyways. Right?
Let's say in Western...
I guarantee you if there wasn't a law
In
that said
Western
that you're
Europe-
going to go to jail for stealing something, you wouldn't have anything. Because all your neighbors would be stealing your shit.
We were talking about driving. We weren't talking about everything. And there are countries like in Western Europe that you can go on the Autobahn.
The Autobahn, I said any street.
Okay.
I live on a cul-de-sac. I don't want you driving 200 miles an hour down towards the end of the cul-de-sac. Right? So you want there to be contract enforcement, don't you? I mean, clearly you do, or else we wouldn't have it. And what we have is a reflection of what we want. Okay, so let's see if we can adjust this a little bit. So somebody makes an offer. Now, the most important aspect of this isn't what you can do with documents, okay? Because what you're going to learn is that, and the system knows this. You guys have heard about people doing processes, and it works. They do an A for V on their house, and all of a sudden their house is paid off. But then their neighbor does it, and they get a letter back saying, oh, this is bullshit. I mean, in so many words. Now, what's interesting about that scenario, I send in a payment instrument that's not a domestic payment instrument to a CFO of a bank, and they don't credit my account, and they send me a letter back. Who does the letter come from? Does it come from the CFO? No. Why not, you think? He's staying in honor with your offer. He's remaining silent. Because if he sent a letter rejecting your offer, that would be a dishonor. So he remains silent. He passes off to a third party. Hey, see if this guy will argue with you. Because if he sends in the offer, if somebody else sends in another offer, and you start arguing with them, you've now abandoned your claim, admitted that your claim has no merit, and given merit to their claim. Just by arguing with the person who sent you the response, and the response isn't even from the person you made the offer to. And that 99.9% of the time, that's how it's going to go down.
How about
Especially in dealing with corporations and banks.
How about if you don't respond? Do what?
Oh, then you're in dishonor and you agree to whatever they wrote. So they send you a letter going, yeah, everything you sent was bullshit. You don't respond, you just agreed. Everything I sent was bullshit. Right? Isn't that how it would go? If I'm silent, aren't I agreeing? It's an implicit acceptance or an implied acceptance. Demonstrated through your actions.
How much time does the CFO have to respond?
How much time did you give him to respond?
Well, if you did an accepted for value on a statement and send it to him, I didn't stipulate any time.
So you didn't do it through a notary or anything and have a notary's letter of presentment with it?
No.
Because if you did that, you could put it in the notary's letter of presentment. Or you could have your own cover letter that goes along with it. Here's the contract. I'm sending you in this tender of payment. You have 10 days, 30 days, 60 days, 90 days, 365 days, however long you want to give them to reject this, to rebut this, I wouldn't give them the opportunity to reject or rebut. I would say to send me a statement of account showing a zero balance. You got 10 days. Send me a statement of account showing a zero balance. If you do not respond within 10 days to the notary named and address provided herein, the notary will be certifying your dishonor. See, now what I've done is I've used a third-party public witness to certify their dishonor of my offer, because they won't send anything to the notary. They'll just ignore it like it didn't happen. Because they're accepting. They're agreeing. Or they pass it off to legal counsel or the secretary or someone, some third party again, not the CFO. You won't get a letter from the CFO, yeah, this is John Smith of Chase, and I'm rejecting this. This is bullshit. This has no merit. Can you pass the microphone? Careful, you're in front of the speaker, so it might get whistly. Is it on?
Question. So since the CFO is not responding to your response or to your letter, and they pass on to someone else, can you do the same thing and have a third party respond to that?
Yeah. No, well, you wouldn't have a third party. You could respond to it, but do it through a third party witness so that you can certify their non-response. Because if they don't respond, what are they doing? They're accepting it.
Okay. All right.
That's the power of notary presentment.
I thought that if you do not respond, meaning the CFO, that's in dishonor, because by being silent, you've taught us that it's being in dishonor.
It is a dishonor.
But you're saying it's an honor.
But it's an implied acceptance. Right?
Right.
Bring into play the Tweedle and Prudent doctrines as silence is equated with fraud, where there is a legal and moral obligation to respond, and where a question left unanswered or offer left unanswered would be totally misleading.
Yes.
Back to that original statement, it's obvious that the CFO is going to give it to their legal counsel, so you could argue with them, and then after that, you're in that other predicament.
Yes.
So how would you handle that situation?
If I got a letter from legal counsel,
Correct.
I'd do a conditional acceptance. Weren't you guys paying attention? I would say, I am in receipt of your letter dated blah, 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 and I accept your offer to contract condition upon proof of claim that the payment tendered on such and such a date is not sufficient to settle and close this account, discharge all debts associated with this account, And your response must rebut point by point the attached affidavit sworn to under penalties of perjury, under your unlimited commercial liability, that bomb, 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 bomb. Go down the list. List the things that you expect from them. Go, I accept your new offer, condition upon proof of claim that this ain't paid for. What have you just done? You're in honor, you've conditionally accepted their contract, and you've put terms back on it. Sign a sworn statement under penalties of perjury that I owe that money, that you didn't just get paid. And when they don't, and I certify it through a notary, what do I have? A claim. I now have a claim certified by a third party that, hey, I got their letter, I sent them a conditional acceptance. They didn't respond within the time allotted. And put in your letter, put something in effect of a response in any other form other than an affidavit sworn to under penalties of perjury, under your unlimited commercial liability, rebutting point by point the affidavit attached here too, would be considered a frivolous response. Now we get to use the word. Right? It's contract, guys. It works both ways. You're not a victim to some big bad system. It's all contract. They just got it wired. We don't.
That's a hammer.
It is a hammer.
Very often the third party, when they respond, they don't have any certified letter. So technically they can't even prove that they talk to you.
No. And it's funny because in most of the presentments I do, hardly ever have I even gotten back something with someone's name on it. They won't even put a name on it. They won't put a signature on it. They're just going to make a bunch of allegations and see if I'm going to argue with it. They'll send back a letter going, yeah, we looked at your paperwork and it may be fraudulent. It may be invalid. They don't even make any positive statements. They're just trying to see if I'm going to argue with their new offer or if I'm going to give it any merit.
When you get these letters, for instance, from the IRS or somebody, can you start off by saying, I received without prejudice your letter dated? Does that preserve your rights?
I received without prejudice. I
think that preserves your rights.
You don't understand. You have your rights. You have the right to contract. You have the unlimited right to contract. Boom. You don't have to receive it with prejudice. I mean, if you receiving it with prejudice means I received it, no conditions attached. No other receiving is going to have to happen after this receiving.
No, it's without prejudice. That's a legal term.
So is with prejudice. Like if I want a case dismissed, I'm not going to do it without prejudice. I'm going to do it with prejudice. Saying no, and they can't file this again. That's what with prejudice would mean. I want full dismissal with prejudice. Get it out of here. I don't ever want to see it again. I could do that in the court of law because, again, you guys, I'm going to give you documents and you're going to see how to write it, but guess what? Your true test is going to come in an oral hearing, in an administrative hearing. Got something?
They never let us give you a good explanation of what you're talking about under merit if you'd like.
Yeah, oh no, yeah, I do want you to do the merit thing. I do want you to do the merit thing. Yeah, let's. If you guys can pass one of the microphones forward, I'll have Gordon give you a breakdown of merit because he does a very good job of breaking down merit of a contract or acceptance or a claim.
Keeps speaking of merits. Excuse me. I got it on. Can you hear me? Merits. What is meant by merits? Black's Law Dictionary defines it one way as strict legal rights. Does that help you understand it? Good, it didn't me either when I read it. But then I got into Webster's New World Dictionary, Third Collegian, and I really enjoyed that because it defined merit as quality deserving reward. I said, well, what does deserving mean? Because I go look up every word I use in the English language almost now. Because I thought I knew what things meant. I thought I knew perfect meant like perfect, flawless. No, it means complete or whole also. It can mean flawless, but there's lots of words that mean lots of things. So merit, quality, deserving, reward. What does deserve mean? Does anybody think they know? Let me back up just a little bit that helps me to grasp certain meanings of words, because some of my friends say, Gordon, why do you say that means this? There's 10 definitions and you choose number 6. I said it just speaks to me. You're going to have to find what speaks to you, and I go through like Bouvier's and 24 different dictionaries, all sorts of different ones. Every time I see a new dictionary, I go look up a bunch of words that I think I know based on. But let's step back for just a moment if I can bore you. How many of you have seen in a federal court building the statue with the blindfold and the apothecary scale held aloft? Does anybody know who she is? She's justice and she's blind, right? Yeah, you're suckers. You buy everything. Quit believing anything. Start doing some study. I'm going to counsel you. You must, before you do some of these processes, please study. You're going to hurt yourselves. You're just going to cause yourselves lots of problems. It's not going to be inordinately difficult to bring you up to speed if you can break it down and get a little bit of study in. And let's look at it. Her name is Themis. Webster's defines her as Themis. Verbatim, a goddess of law and justice, daughter of Uranus and Gaia, represented as holding aloft a scale for weighing opposing claims. She's not blind. She's just there to weigh the claims. She doesn't want to see anything else. Brandon told you, if you can't stand on your claim, you've got nothing coming. This word claim is going to come up everywhere, such as in the word laches, L-A-C-H-E-S. Laches and estoppel. I like the way Webster's defines laches as opposed to Black's Law Dictionary, because it speaks to me that definition, which is thus: failure to do the required thing at the proper time. And then in parenthesis, it says example, inexcusable delay in enforcing a claim. Claim. It's all about claims. What's a contract? That's where you go make you can't go in that, you go in that contract court. We go in and we hear the judges are unfair, they did this or did that. I will tell you, these judges are absolutely perfect. They know what they're doing. We've seen the enemy. Who's the enemy? That's right. The government always does it right. What? If you can get some basic rules down, the government always does it right. And you have to find out what you did wrong. And it's a hard thing to stomach at first, but once you start doing that, it's a claim. You got to make a claim, and you got to stand on it. We're going to go to this merit thing now. Merit, quality, deserving, reward. Deserve, have by conduct a claim to. Have by conduct a claim to? I was in court.
Hold on, Gordon. We need to switch the video. Let's go ahead and switch the video before we go into merit.